Even though FBI Director James Comey recommended no criminal charges against Clinton, he did seem to suggest that she faced some form of punishment.
This is not to suggest that in similar circumstances, a person who engaged in this activity would face no consequences. To the contrary, those individuals are often subject to security or administrative sanctions, but that's not what we're deciding now.
Well, joining me now is James Melendres. He is a former federal prosecutor who specializes now in cybersecurity cases, but he led some of the DOJ's highest profile cases, including the prosecution of former CIA Director David Petraeus. Mr. Melendres, thanks for coming on today.
Thank you, Chuck.
All right, interpret for me that last comment by Director Comey, that he's basically saying there are some charges that could be brought against her. He called them security charges. What does that mean? Not getting a certain security clearance? What exactly was he referring to there?
Sure. So there are a variety of non-criminal consequences that may attach to investigations that involve the mishandling of classified information. Those administrative actions are not within the purview of the Department of Justice or the FBI, but are rather handled by, for example, the agency that may have sponsored and granted the security clearance of an individual who is deemed to have mishandled classified information in some way. So to be clear, Director Comey was not speaking about any type of criminal charges that might be of consequence, but of of administrative actions that might be taken.
And so what you're saying, essentially, this would be up to, in this case, the State Department. If they wanted to take action, he has given them the material to take action.
That's correct.
Okay.
Often in mishandling cases, the sponsoring agency can do a variety of things, including revoking a security clearance or not sponsoring one going forward.
All right, let me ask you, because it's the comparison that every lay person in politics makes, which is what David Petraeus got prosecuted for and what Hillary Clinton did not get prosecuted for. What are the similarities? What are the differences?
Sure. So I'll use what Director Comey said today in his statement as a frame. And just to be clear, everything that I'm going to refer to is in the public record in both cases. The core of Director Comey's statement concerned the lack of evidence regarding willfulness. And I believe that the term he used was that in the investigation of Secretary Clinton and her home server, that the FBI had not uncovered any evidence of clear willfulness. Now, in criminal prosecutions, as a general matter, and this is Criminal Prosecution 101, the government is required to prove at least two things. One is the required mental state, and the second is the physical act that constitutes the actual crime. And according to Director Comey today, the FBI in this investigation did not identify information that it believed would meet the standard of willfulness. Now, by contrast, in the prosecution of former Central Intelligence Agency Director David Petraeus, the department and I and the FBI were comfortable that there was evidence that satisfied that willfulness standard. And in particular, and this is included in the plea agreement and the factual basis that former Director Petraeus executed with the government, there was information that was developed based on recordings that his biographer had made of conversations. And in particular, in those recordings, former Director Petraeus said explicitly and specifically that the information in the black books that he shared was highly classified. And then just about 2 weeks after making that statement, he went ahead and by email confirmed to his biographer that he was going to share the black books.
So there was
her.
obvious evidence here that he was willfully doing this. Director Comey, what you're saying today is Director Comey did not have that level of evidence with Secretary Clinton.
That's correct. And the other point that Director Comey made, which I think bears repeating, in particular in contrast to the Petraeus prosecution, was that in addition to a lack of clear willfulness in Secretary Clinton's matter, there also were not aggravating circumstances. Director Comey suggested that some of those aggravating circumstances could have been evidence of large-scale transmission of classified information, evidence of disloyalty to the United States, or obstruction of justice. turning to the Petraeus matter, and this again is included in the plea agreement, which is public, former Director Petraeus acknowledged and admitted that when he was interviewed by the FBI at the CIA, he told them that he had not shared classified information with his biographer, when in fact he knew then and there that he had.
got caught
So that is
lying.
another distinguishing feature. Yes.
Right. He bottomly got caught lying. Let me get you to react to something that the Speaker of the House said. He said, declining to prosecute Secretary Clinton for recklessly mishandling and transmitting national security information will set a terrible precedent. As a former prosecutor, are you worried about that we've lowered? He's basically worried that we've sort of lowered the standard of following the rule of law.
Yeah, that's not something that I'm worried about based on the director's statement today. You know, what the speaker is referring to, I believe, is the statement that Director Comey made about the recklessness, in his opinion, with which some of these email arrangements were conducted. Within the statute that governs the mishandling of classified information, that is Title 18, United States Code, Section 793, there are two provisions that guide the mental state required. The first is one of willfulness, and that is 793E. In 793F, a sub-provision that follows immediately after the willfulness discussion, there is a gross negligence standard that can be applied in these types of prosecutions. Now, it is true that that standard exists within the statute. However, to my knowledge and in my memory, the department has never used the gross negligence standard to prosecute a 793 felony case.
Would this have been a difficult, you believe this would have been a difficult prosecution to make stick?
Yeah, based on what the director said today, the information that's in the public record, it appears there was not evidence of willfulness.
And
the
would you have
negligence,
recommended against prosecution as a prosecutor at that time? Something like this hit your table with this evidence or lacking of some parts of evidence?
Based on the director's statement today, I think it was the right conclusion.
Okay.
And I think his statement that it would be unreasonable for a prosecutor to proceed is correct.